Article 15 of the Budapest Convention on Cybercrime, or about the broader issue of how to protect the rights of people when investigating cybercrime. It's organized under two projects. Both of them are joint projects of the Council of Europe and the European Union. It's under the Eastern Partnership Project, and it's covered also under the Cybercrime IPA project for Southeastern Europe. The rationale of the event is, I put it here on a slide, that on the one hand, governments have the positive obligation to protect people against crime, but also against arbitrary interference by public authorities when preventing or investigating crime. And so the objective of this event is to promote respect for rule of law and human rights when applying criminal justice measures against cybercrime and when securing electronic evidence. I would like to underline here criminal justice matters, because the Budapest Convention is a criminal justice treaty, but we will later on have to see how this relates to other issues from so-called cyber warfare, national security, intelligence, and other matters. And indeed, in order to meet this objective, we believe that if we support countries in the implementation of Article 15, they will get closer to it. We know some people have different views and they would wish a broader approach to the matter. Okay, then we have the room in the middle.
Hello, I'm sorry, we are just registered.
İşitirsen bana, işitirsen. Bir, iki, üç, dört, beş, bir, iki, üç, dört, bir, iki, üç, dört, bir, iki, üç, dört, bir, iki, üç, dört.
Okay, let's continue. The way we want to organize the event today is we wanted to start 1 hour ago, which we didn't, but that's not a problem. So in the first session after these opening remarks, we will discuss what are the threats. What are the threats of cybercrime? How relevant is cybercrime? Some people think it's completely exaggerated, so we discuss, is there really a threat? We want to discuss threats to security in a broader sense. We want to discuss threats to human rights. In session 2, after a coffee break, we will then discuss investigating cybercrime and securing electronic evidence, and then what conditions and safeguards apply in the criminal justice arena. We'll discuss in more detail Article 15 of the Budapest Convention, the case law of the Court of Human Rights, but also issues related to the protection of personal data. then we still want to start before the lunch break to discuss how Article 15 is applied in countries participating in the two projects. So there we would like representatives from each project area to present briefly in a few minutes how conditions and safeguards are applied in your investigations. Okay, so please be prepared to speak for 7 minutes or so per country on how you apply this in your respective country. And then we have in session 4, which will take us to about 4 o'clock this afternoon. We will start about 4 o'clock this afternoon. We will have then a very interesting debate about open issues. In particular, the issue of law enforcement access to data held by private sector entities, internet service providers and others. The issue of transporter access to data. And also the issue of national security versus criminal justice. Where are the limits? What applies in the national security arena? What applies in the criminal justice arena? And then we should still come out at the end of the day with some conclusions about the way ahead on protecting you and your rights. Is it clear? Can you still hear me? Okay, because I cannot hear my own voice over here. Let us now start with session 1. What are the threats? How relevant? How relevant is cybercrime? When we talk about cybercrime, and if we apply the philosophy of the Budapest Convention, we talk about offenses against computer data and systems, like illegal access, data system interference, illegal interception, and so on. System interference may also include botnet attacks and so on, but also offenses by means of computer systems. And in the Budapest Convention, as you know, there are 3 or 4 offenses mentioned. That's computer-related forgery, fraud committed by means of computer systems, child pornography, and also IPR, intellectual property-related crimes. But as you know also, the procedural law of the Budapest Convention and the international cooperation provisions relate to any electronic evidence, electronic evidence in relation to any crime. So that makes it very broad. We know when we talk about cybercrime, we need to look at tools and infrastructure, malware, botnets, the issue of criminal domains and the abuse of the domain name system, the question of organizing for cybercrime, the underground economy where goods and services can be bought, the issue of organizing for cybercrime, organized crime, but also hacktivism, the so-called advanced persistent threats against political or economic targets. We need to talk about criminal money on the internet, including money mules. And we have to take into account the technology and the context, namely in particular crimes committed via or on social networking platforms, and also the links to cloud computing. I will not go into the details here because there will be other speakers on that. Just a few points. The Norton 2012 cybercrime report talks about 1.5 million of consumer cybercrime daily with a global price tag of $110 billion a year. The changing face of cybercrime, where now much more takes place on social networks, but also on mobile devices. And they claim that 4 out of 10 social network users have fallen victims to consumer cybercrime. The RSA monthly talked about 50,000 unique phishing attacks in August, and also monthly changes in the threat landscape, also in relation to mobile malware. Now you can say that these are, if you talk also about Nord and Symantec and others, you talk about that it's an interest of them to explode and exaggerate the risks. But then when you look at how people, for example in the European Union, perceive or experience cybercrime, there was the Eurobarometer on cybersecurity from last July, which I think they did something like 26,000 interviews or so, and they concluded that 53% of EU citizens access the internet at least once per day, 40% are concerned about theft and misuse of personal data, 38 are concerned about security of online payments. Okay, this is perception, but 12% of internet users have experienced online fraud, 8% have experienced identity theft, and 13% have experienced problems in accessing online services because of cyber attacks. And more than 80% believe that the risk of becoming a victim of cybercrime has increased in the past year. So this is not now something done by antivirus vendors or others, or by the computer industry. This is a survey done among a large number of citizens in the European Union. When you look at fraud and the experience, the Internet Crime Complaint Center in the USA received more than 300,000 complaints in 2011, with $485 million of loss reported. The BKA in Germany, in the crimes they registered almost 60,000 cybercrime offenses in the narrow sense in 2011. Narrow sense meaning not credit card fraud or other offenses committed by means of computer system, but where computer systems were manipulated for fraud purposes, like man-in-the-middle attacks or similar. So 26,700 computer-related fraud cases in the sense of Article 8 of the Budapest Convention, 15,700 cases of interception of data in the sense of Article. And we all experience sabotage. And the BKA also, in their database, noted more than 220,000 cases where the internet was used as a tool for crime. So again, this is not data coming up from the industry, from interested parties. These are the cases actually recorded in the German Federal Police database of crimes. We have something from Internet's botnets. We have the attacks, and maybe Andrew can come back later on, how they're taking down botnets every month, another one. And we also have DDoS attacks against critical information infrastructure. I just picked out a figure just before traveling. On the 1st of November, ARPA-CERT, they noted more than 1,200 denial of service attacks within the past 24 hours on their sensors. Just gives you an idea. We all know about Estonia, Georgia, Korea attacks. We know about DDoS attacks against civil society organizations, against independent media. We know about hacktivism and so on. So there's a range of threats there. There's also the question of terrorist use of the internet for different type of purposes, for recruitment, incitement, training, for logistics, and also potentially for carrying out DDoS attacks. And there is the online child sexual violence thing. Now, you will certainly accuse me of always saying the terrorists and the children, and with that you get away with everything. But it's an issue. It is an issue. Yes, they also agree in the other room. It is an issue, and I participated not so long ago in an event. I cannot say where this was. There were specialized law enforcement dealing with sexual exploitation of children issues, and they said, here is a picture of a child raped, pictures, materials put on the internet at the age of 2. Here is a picture of the same child at the age of 4. Here is the picture of the same child at the age of 7. We have tried to identify and rescue the child for years. We don't get it. And every now and then, the same child comes up. The same child is abused for years without interruption. So there is a real issue there that we have to address. So, question that we can discuss later on, how relevant is cybercrime? We have to underline the positive obligations of governments to protect people against crime. There are threats to security, but there are also two threats to human rights. I don't like to call it a balance that we have to find, because cybercrime is a threat to the rights of people. So we're not talking about the balancing investigation versus the rights of people. Investigation should ideally also protect the rights of people and help people to be protected against cybercrime. With that, I would like to now give the floor to other colleagues. We have Sahid Jamil from Pakistan. We have Andrew from Microsoft, and we have Daue. What? Daue like flower. Daue Korf, fantastic person, activist on the human rights side, a lot of experience with also the European Court of Human Rights. You did an internship 30 years ago? A long time ago. And he won the case at the Court of Human Rights also. So we have 3 experts from different regions, different sectors, sharing now their views, and then we will have a short discussion also to see from you, how are you seeing cybercrime threats in your respective countries. Sahid, you want to start?
Thank you. I'm going to speak a little loud, so if anybody cannot hear me, please let me know so that I can speak up even more, because I know we have challenges. My name is Sahid Jamil. I'm a lawyer. I come from Pakistan, and we have faced a lot of challenges in my country, not just related to cybercrime, but also related to cybercrime and cyber being used for terrorist use, whether it's money laundering or coordination or actually getting attacks out there. So it has a real life impact when it comes to my country. We've seen cases starting from simple stuff like bank fraud, ATM fraud, online fraud. People will be surprised to know that, in developing countries, there are very sophisticated spear phishing and phishing frauds that do take place. We've actually found that banks that are only located in my country are having mass amounts of phishing fraud taking place, a lot of emails going out, trying to basically entice account holders to click on certain websites and give their personal information away. We've had instances where terrorists have started using the network to coordinate logistics, as was just mentioned, and also attacks to talk about what's going to happen. How do they coordinate these things? And I think it's important to also mention that in every case related to terrorism that we've seen, Too high? No. Can you hear me? No. Is it better? Okay. And we've seen instances that in every single case where you have a terrorism case, you would end up. You would end up. Is this better? Oh. Is this better? There's a feedback. Somehow there's a feedback. I'm sorry. There's a feedback. Is this any better? No? I'm sorry. Is this any better? Oh, okay. Okay. There's a loop. Okay, fair enough. All right. Oh, okay. There's a loop. Okay. I'm that good. Oh God. Okay. So someone's got their mic open on some other device. Oh God. Who's streaming into remote participation? Probably that's what's happening. No. Streaming into remote participation. Probably that's what's happening. No. Never know. Let me try again and see if anybody can. If this is okay now, we have to wait a few seconds to see if there's a loop back. Is that better? Okay. All right. Good. Thank you. Thank you. Okay. So I mean, in every single case, and we have dealt with certain serious matters and serious cases related to terrorism, and you find that whenever an investigation or prosecution begins, it is invariably the case these days. In terrorism cases, that you would have electronic evidence. So cyber forensics, how to admit that evidence into court, how would you then explain that that evidence can be a part of a commission of a crime? These are all issues we have had to deal with. And we had instances where large, what we call hundi and hawala organizations within Pakistan, which are basically money laundering operations, which are illegal. Basically, you make a phone call and a guy in another country just goes and delivers a certain amount of cash to somebody else, was broken down a few years ago. And these are the figures that were quoted by the investigation agency that I work really closely with, that they found actually approximately $1 billion a week, this is in Pakistan, that the money that was being transmitted across this network. So, I mean, those kind of things are actually happening, or we've been aware of it. Government websites in my country and in my region have been attacked. And every single case that we see of cybercrime, whether it's related to illegal access or theft of data, for instance, we found that IPR becomes an integral part. And one of the things we've noticed is whenever you do, whenever law enforcement looks at an investigation, it invariably tries to find copyright infringements as well to strengthen its case. So IPR violations are, from at least our perspective, an important tool that is used to fight cybercrime. And we have seen certain platforms. People may have heard of eBay and Alibaba in China. Quietly, there's a platform that actually runs out of Pakistan called TradeKey. People don't realize where it's from. It's apparently the third, fourth largest. And most of the stuff that you can get on that is really counterfeit products. And so that is a sort of a mixture of cybercrime and IPR infringement. I mean, in a country like mine, the issue of cyber forensics became such a huge issue that people may be aware of the incident of Osama bin Laden and then the incursion by the U.S. forces. The aftermath of that led to a situation where there was an investigation by the Supreme Court. And in that, somebody had initiated a whole, brought facts to the record that the government of Pakistan had actually, or the ambassador of Pakistan had actually attempted to contact the U.S. Commander-in-Chief, actually the Chief of Army of the Armed Forces, and proposed that the U.S. should use their influence not to let a coup take place in Pakistan. What eventually happened was that the entire evidence related to that case, which came under investigation by 3 Chief Justices of our high courts, ordered by the Supreme Court, was based around simply BlackBerry data. Every single day, all that you heard was, when are they going to get that data? Are they going to get that data? And how do you do the forensics on it? And the implications of that would have been the overthrow of the government, because the Supreme Court could have actually initiated a case related to sedition and basically treason. So the report actually came out, and I won't go into details, but that's the seriousness of how cyber forensic and cyber crimes and things of that nature can sort of have impacts in developing countries. We also have had cases where people in business have started saying that, look, we need to have better legislation so we can create a secure environment, so we can have outsourcing and better economic environments. We've seen issues related to blasphemy. You know that Pakistan has blocked YouTube and on Facebook in certain earlier occasions. The question that arises in a context like that is, should that be a cybercrime or not? And my view, at least, is that needs to be something that's outside this realm. Let me now sort of take a little bit of liberty and speak about something else that I'd like to, from a context of Pakistan and maybe the human rights aspect, because I know we'll be discussing later today. But it's something I feel strongly about, and what the convention actually brings. In Pakistan, although I've mentioned the threats, let me also explain that there are counter threats that actually from the abuse by law enforcement. So you have law enforcement that say, well, we are Should I try again? Let's see. Is that okay? Yeah? So the threats don't just emanate from the criminals, but sometimes what happens is in this context, the threats can also emanate from law enforcement in developing countries, countries where there may not be a good enough legislative, judicial, or oversight or governance mechanism. So in my country, one of the biggest problems industry and many
Is this law enforcement interference or who's interfering?
well, abused by law enforcement, bribery and stuff like that.
That's okay.
Yeah, is it okay? Sorry. So I'll give you examples, for instance. This is fine, I'm so it's okay. Is that better? Is that all right? Okay. It's not my voice, is it? I mean, okay. All right. You never know. There might be malicious sound.
It's the topics you're talking about.
It's the topics, okay. So so there's this other aspect where I mean, for instance, let's take as I said, the example of what we call gray traffic or voice over IP. So because there is this sort of unclear issue as to whether voice over IP is legal or not legal in my country, what ends up happening is that law enforcement would end up going to various organizations, businesses who are doing what we would consider legitimate business, and starts sort of extracting money, saying that if you don't send X amount of dollars to our office every sort of month, we are going to institute an inquiry and investigation against you. And that has been something that has continually happened over the last 4 to 5 years since these different legislations related to these sort of crimes have come up. The process, the judicial process, did not actually provide for specific safeguards and provisions as to what happens when these sort of investigations are initiated. What rights do people have when they go to court? How does a judge come to an early conclusion on whether the forensic evidence is good enough that it will lead to a conviction or not? It's very difficult unless you go through the whole entire trial. And so a lot of abuse started taking place. We've had several instances. Sometimes there would be a simple mistake or a mistaken identity case, and the guy would be spending his months in prison just because they got the wrong person. So that was a real concern. And the legislation in 2007 that was proposed by the previous regime in my country was called the Prevention of Electronic Crime Ordinance, against which we advocated and lobbied against, saying that this was not consonant with, not just with the Convention on Cybercrime in its definitions and provisions and procedures, but specifically because it did not cover safeguards, specifically because the human rights aspects were not actually addressed. So that advocacy with a lot of YouTube videos and actually writing in the press, going on to television, managed to actually ensure that that legislation didn't go through, and it came back to Parliament. And this time, I'm happy to mention that it came back to sort of industry, a multi-stakeholder dialogue, where a consultation took place that let's develop a draft that does provide these safeguards. Now, when we did that, we didn't know where to look. We looked at ITU documents, we couldn't find anything on safeguards. We looked at UN documents, we couldn't find anything on safeguards. We looked at the Commonwealth model law, we found something there. But eventually, when we looked at the convention, it had a very clear article that said, these are the sort of things you need, the principles on which you need to sort of work on. So it doesn't give you, it's not prescriptive, it doesn't give you details, it doesn't give you language necessarily. But what it does do is provide you with guidance. And so we use that. And a lot of different things I'd like to mention that we included in and the reason I may not be very, very coherent is because I've been up all night getting the latest version out to the select committee in my country just this morning. And it will be discussed tomorrow morning in front of the National Assembly, that legislation. I'll give you an example of the things we've included within it. The first is that you cannot start an inquiry unless you lodge an actual case, a copy of which goes to court. So you can't have a secret inquiry. If you're going to start an inquiry, you have enough evidence, you bring it onto record, you cannot use it for abuse. You cannot go quietly to a person and say, this inquiry will commence and we will arrest you, you won't, and we will not bring this before the notice of a judge. Second, all powers, with the exception of preservation, require a warrant. The legislation itself provides details as to what the criteria will be if warrants are issued, and different criteria applies to whether it's real-time interception, which is a higher standard, search and seizure, slightly lower standard, and other things of a different nature which are provided in the convention. So these are the sort of things that industry really advocated, saying we've seen these abuses, we want that our civil liberties and human rights should be protected, and really they were guided in large part with the principles of Article 15. It was really discussed in a lot of these meetings, how do we protect this? And so I just wanted to add that. We couldn't find it anywhere else, and that sort of explains I guess to at least us, that we need to find internationally documents that give guidance to governments when they're drafting legislation, not just about saying, okay, here's a crime, here's how you get your criminals, but also saying, well, here's where you have the proportionality, here's where the safeguards are, and here's how the judiciary comes into play. And I'll end there. Thank you very much.
Thank you. I'm happy to see that things are proceeding so well in Pakistan. It's one of my many home countries. I spent some years in Pakistan 20 years ago dealing with drugs and tribal areas and Mujahideen and all these interesting people. But we also, it was great for me to go back 2 years ago. In the beginning of 2010, we had a workshop in Pakistan organized with in cooperation with Sahid, but also in cooperation with Microsoft. So we had a very good training event, and we used that to have also some discussions with other officials, which then helped perhaps to take this process of legislative reform along. With that,
can I intervene just for a second? Yep. I don't want to plug this, but it's actually true. When we had that discussion, it was the law enforcement in the room when we were having these consultations that constantly kept saying, we want the powers that are in the convention, we want the powers that are in the convention, we want those things that are in the convention. It was really, it was odd. We didn't have to lobby them anymore because they understood the importance of it. Just wanted to add that. Thank you.
And of course you have a very strong Supreme Court system in Pakistan that also controls powers and so on. And one point we discussed at that time, there was no requirement in the law for warrants in many cases, but de facto, because of case law of the court in Pakistan, de facto law enforcement had to get warrants every single time. Andrew, more private sector perspective now.
Thank you very much. It's a pleasure to be here speaking to the Council of Europe on this at another IGF. So I appreciate the opportunity to share the private sector's view, or at least one participant from the private sector. There are three key points that I want to make today. And the first is that I don't actually want to address the question of is it relevant? Yes, of course it's relevant. There are so many dimensions of cybercrime. It is growing and changing at a huge pace, and it is one of the most important dimensions of public safety and national security today because of countries' dependence upon ICT and upon the internet. So that's one point, is that it's changing and it's important to governments. The second is there are significant capabilities in the private sector, and you need to include private sector at the table as you're figuring out how to tackle this set of problems. And lastly, I would say that Microsoft is committed to advancing the state of the art in addressing cybercrime and cybersecurity and cyber attacks. So with that as kind of framing for this, I want to drill a little bit about, we see four kinds of basic attacks. We see cybercrime, industrial espionage, where it's companies spying on one another using computers. We see military espionage, and then there's cyber war, or cyber attacks from nation states. So the vice president of the Trustworthy Computing team, Scott Charney, has talked about this over the course of years. We are making good progress on all of these. Scott Charney actually says that military espionage is one of those dimensions that we're going to have limited ability to affect. But Microsoft is active in addressing cybercrime, as well as in providing protections for companies to protect themselves, and also now more active in the state-on-state dialogue around attacks. One of the most challenging areas for us is that nation states actually view that as an area where they don't want private sector engagement. Depends on the government, but some governments are less interested in private sector engagement. I believe that it is critically important that the private sector be involved in those because the dividing line between national security and public safety is really very blurry. It depends on which way you look at it, what day of the week it is, and what hour of the day it is, and the external factors. The other reason that I would highlight that is important is that the tools at use are very similar. The tools that a criminal uses to create a botnet are the same tools that a nation state might use for a denial of service, or exploiting a targeted attack on an industrial target is not very different than a targeted attack on a state. My background is in product development, and then I moved over to security, and I ran the Microsoft Security Response Center for a number of years. This is the team that's responsible for every month to release the security updates that protect the systems, 1 billion plus systems around the world. I participate with industry groups. There's a group called ICASI, which is the Industry Consortium for the Advancement of Security on the Internet. And this is the incident response teams from IBM and Nokia and Amazon and Microsoft and Juniper and Cisco, where we collaborate together in times of crisis to actually deal with those vulnerabilities or those issues that span companies. And it's the technologies that all governments around the world are using. That's an example of capability. There are two examples of capability there. One is that Microsoft releases updates every month. And you need to get those distributed to your customers, to your governments, to your desktops. And the industry actually recognizes the need for collaboration there. On the last point of advancing the state of the art, we do this both on the research side as well as on the response side. Alexander and Zahir have mentioned botnet takedowns from the Digital Crimes Unit within Microsoft. That's a team of lawyers and technicians that are using innovative tactics to actually address botnets. And my team has actually just completed some research as well that takes a look at economic, social, developmental factors and attempts to determine, asks the question, can you look at these kinds of factors and predict what a country's security, cybersecurity posture would be? Our inspiration from this was taken from a report that said with the increase in broadband penetration, you see a positive increase in GDP. We wanted to see if you saw an increase in protection activities, would you see a corresponding decrease in cybersecurity exposure? The research is preliminary, and it does not demonstrate causality, but there is a very strong correlation between a country's cybersecurity performance. This is measured by the Microsoft metric of from the malware, from the malicious software removal tool, which is the computers cleaned per thousand or computers cleaned per mil. If you look in the Security Intelligence Report, you will see on every 6 months we publish. Every 6 months we publish rankings of countries. And for the infection rate in that country. And you see some countries that are have very low infection rates, and other countries that have moderate and much higher infection rates. And the three variables that we were actually able to correlate to a country's infection rate, one is the London Action Plan. Have they signed on to that? Which is about how do you deal with spam. The other is, are they a signatory of the Council of Europe Cybercrime Treaty? And these are strong. There's a very strong correlation here, and we will continue our research here to determine, are there other societal or environmental factors that will give us an indication of performance in the cybersecurity space. And the motivations for this for us is that we want to show countries and policymakers in countries not just a map of how infected they are or a number that says what their infection rate is, but we want to give them policy guidance that will actually help them address the cybersecurity infections in their country. With that, I will pause. I think that's enough for introductory comments. Thank you.
Actually, Sahid mentioned earlier that sometimes in investigations you can use IPR issues in order to make the case. And when you took down the Rostock botnet, was it that one where you also had Pfizer or one of the pharmaceutical companies to use the argument that the botnet was used to distribute spam with counterfeit pharmaceuticals, right? So there you also made that link in a way for the botnet takedown.
And I would reinforce the public-private partnership that happened on the Rostock takedown. It was the Dutch high-tech crimes unit in the National Police. It was Pfizer. There were researchers at FireEye and at the University of Washington. This was a broad collaboration across academia, across public safety, and industry.
Very good. We continue with Douwe Korf from the Netherlands, but who is actually at the London University.
Yes. Can you all hear me? Does this work? Okay. Just raise your hand if this ghastly interference happens, and I'll stop and wait until it goes. Yes, I'm a human rights lawyer by background. Done a lot of work with the Council of Europe, mostly on data protection, and before that on things like the right to life. I agree with Alexander when you said it's not a question of balance. It's not one against the other. I don't think civil society is against the police or against tackling crime. I mean, civil society as much wants to fight crime as anybody else. I mean, we have children ourselves, so if you see child abuse, you want that tackled as well. I don't think there's... The point is the same online as offline, which is that you have to limit the powers of the state, quite simply because if you do not, you very easily slip into repressive systems. And the internet and the whole cyber world poses new challenges in that regard. And I think starting again from a civil society perspective, the internet is one of the greatest places for social activism, for political activism, for organization. The Arab Spring wouldn't have happened without it. And you then see the same kind of things happening on the internet when state institutions become involved in dealing with activities online, as you have seen in over hundreds of years with police powers being used against offline activities. So we got to come up with the same kind of safeguards. One of the big problems is the inherent transnational nature of the internet. So typically, I'm a member of a small little expert group of the UK Foreign Office on freedom of expression on the internet. And we pointed out to the minister there, Baroness Wazi, you probably met her, who is now responsible for this issue, that you cannot have Western governments arguing for blocking and surveillance technology being included on the internet and then complaining if repressive governments use the same technology to repress political activists. There's a contradiction there. You need safeguards to make sure that powers are properly exercised. And you mentioned it as well, Safia. So I don't think this is a question of the people fighting crime on the one hand and civil society at the other hand coming from totally different perspectives. That we should come from the same perspective when you talk about the rule of law. And another very interesting thing that Xavier said about this drafting of this law in Pakistan. I have a lot of Pakistani judges as students. They come to my university. It's always very nice to talk to them. When you said you only get good law if you have a multi-stakeholder dialogue. And I must say the Cybercrime Convention is another example of originally bad procedure in the drafting, with 19 secret drafts before anything was published. That is not the way to get good law. We've had the same problem just recently in the EU, and I wrote an opinion with Ian Brown on the ACTA treaty. And we defeated it. I think it was probably one of the biggest civil society campaigns I have seen in many, many, many years, in many countries in Europe. And why was it defeated? It was defeated because it was drafted by governments in secret, only talking to interested industry parties and not involving civil society. And then you get a very bad agreement that luckily in this case was shot down. I think there's a similar problem with the Cybercrime Convention. It took a long time, as the American contributor to the report said, before the safeguards and conditions were even put into the Cybercrime Convention. That should have been in the minds of the drafters from the beginning. And when I see several crucial elements in the convention, in particular about cross-border access to data in another jurisdiction, when the explanatory report basically says we haven't been able to find a solution here, and that's crying out for a solution. Just last week it was reported that the Netherlands, nothing new about the Netherlands, has now introduced a law allowing the law enforcement authorities to place malware on computers and to hack computers in other countries. There's no limitation on that. Now, that has massive repercussions in terms of international law. It is an infringement of sovereignty if you use what's called enforcement jurisdiction to do something in another country. There are all kind of big problems with that. I'm not going to come back to a number of these issues this afternoon. Data protection, and I'm very pleased Sophie's here, very, very pleased she's here, is absolutely crucial to this. We're always talking about data, and we're always talking about data that in the end relates to somebody who may or may not have been involved in criminal activity. The EU, but starting with the Council of Europe Convention and now the EU draft regulation, the EEC Directive on Data Protection, are extremely strong measures to try and make sure that personal data are properly used, both in the police sector, what in the EU used to be the third pillar, and in the private sector. And one of the further challenges in this context is exactly that these pillars are merging. The private sector, as you quite rightly said, Andrew, is essential for the operation of the internet. It's essential for the activities of people fighting crime. At the same time, they are not subject to the kind of constraints that public bodies are. And if you can't hand over the enforcement of the law to private sector entities. You need to involve them, but you can't leave it up to them. In the end, your bottom line is the bottom line, and not the protection of fundamental rights. And if a ISP has to choose between allowing freedom of expression or losing a contract in a country, they're going to go and say, well, tough if we have to be a bit repressive, but we have to serve our shareholders. Those are the kind of challenges that we have to try and face in this context. And of course, the additional protocol to the convention is extremely sensitive. Immediately, in terms of Article 10 of the Human Rights Convention, it's all about freedom of expression. Where do you draw the line between shocking and offending and disturbing speech and hate speech? And that line will be drawn differently in different countries, in which case, what law do you apply? The question of jurisdiction is another one that is not addressed in the Cybercrime Convention, one of the big challenges. I think I'll leave it at this. We're just putting an awful lot of these difficult issues on the table rather than trying to resolve them, and hope that we can discuss a few of those. Thank you. Oh, one thing to mention, a report that Ian Brown and I wrote for the Global Network Initiative on digital freedoms. Very easy to find, just type in GNI and digital freedoms and you can download it. It addresses an awful lot of these issues.
Indeed, the report by Dower and Ian Brown. I think Ian will join us later today. It's very good, and I would also personally agree with almost everything. But there are a few points we need to discuss further, and maybe the last session this afternoon, maybe an occasion on the issue of transporter access. Yeah, the Cybercrime Convention Committee is working on that particular point, and hopefully in the next plenary session in 1 month, on 5 and 6 December, we will have a report to present, which may clarify some of the things that are there and may look for some additional solutions to deal with the problem. On the question of having a public international organization, negotiation of a treaty, fair enough, it was before my time. But the thing is, the last 7 or 8 versions were public, and in this last phase of negotiating the treaty, a number of things were put in. Perhaps additional issues would have been brought in earlier. But I must say, as we go around the world with the treaty as it is, it works very well. And we find in the treaty, and we find in the explanations in the explanatory report, we find many of the answers. So I'm positively surprised about how this treaty has stood the test of time, but also the test of different regions of the world to work in. But we can come back to this. Cybercrime in your countries, your areas. Who wants to start? Branko. Is there a portable microphone?
Well.
Good morning, everyone. My name is Branko Stamenkovic. I'm the special prosecutor for cybercrime of Serbia. That means I'm the head of the office for this crime in Serbia. And first of all, do you hear me? Can you hear me? Right? Okay, great. I want first of all to thanks to all of the previous contributors to this discussion, and although I would like to concur with some of the observations from professor here, I would like to support let's say the side of the fight against the cybercrime, which belongs to the Convention on the Cybercrime of the Council of Europe, because for us as the practitioners of the cybercrime Convention is it's the tool for international fight against the cybercrime. And I believe that later on we are going to have the chance to discuss about that in more details. Still, I completely agree with Alexander about the test of time for the Budapest Convention, because it was assembled in 2001, I believe, put into the force in 2004. Now we are on the end of 2012, and we are all witnesses of enormous development when it comes to the hardware technologies, when it comes to the software technologies, and still that kind of the international treaty as the Budapest Convention, when it comes to the implementation of the broad framework for substantive and procedural law is still there and very much alive and kicking, and very much of the use for all the representatives of the countries when it comes to the executive power, national legislation power, judiciary, prosecution, legal enforcement agencies, and civil society as well. Private sector, of course. When it comes directly to the state of the play, when it comes to the cybercrime in Serbia, we are going to talk about my colleague Judge Paunovic and me more later on when it comes to the presentations of the frameworks in our countries. But as it is at this moment, I just want briefly to introduce to you the framework of combat against cybercrime in Serbia, which is one of the, I believe, better ones, because we are lucky enough to have the special piece of the legislation in place. Many of you present here know that, and from 2006 we have the law on the organization of the government authorities for combating cybercrime, which envisages and provides the specialized authorities within the Ministry of Interior, within the public prosecution, and within the court system, within the judiciary when it comes to the combat of the cybercrime. We have the special chapters with regards to the cybercrime within the criminal code. We have special definitions of the computer and cybercrime related terms within our criminal procedural code. We have several other laws in place, for example, and namely the law on electronic communications, the law on the secrecy of the data, law on the protection of the public data and personal data, and so forth and so on. So there is a vast legal framework in Serbia at this moment, which on one side is giving the power, let's say, to the public authorities to tackle the problem of the cybercrime, and on the other hand gives the safeguards and checks and balances in hands of both of the civil sector and the specialized institutions within the framework of government in Serbia for control of the access to the data, control of the flow of the evidences, and so forth and so on. So I believe that in Serbia at this moment at least have a very balanced system of the checks and balances, and very balanced system of the safeguards and powers on the other side when it comes to this area, within this specific area of the cybercrime, of the criminality at all. So the results which we have to present for country, because we are a relatively small country in Europe, 7.2 million people at this moment, is showing that we have in the last 3 years a shift of the criminal acts and criminal activity. For example, in 90s and in the early 2000s we have more of the IPR infringements, more of the credit card frauds or attempts of the credit card frauds, and so forth and so on. Now we are slowly shifting towards the more serious computer-related frauds, more serious commercial espionage, more serious cases of the child pornography, of the, let's say, piracy by misusing of the radio stations, illegal TV stations, and so forth and so on. So the fact is that at this moment, and in the years behind us, the cyber criminality is changing, and that's something what we have to acknowledge as a fact, that we cannot just lay down and be competent and confident in legal framework we have, or in successes which we achieved in times before. We have to be ready for whatever comes today and forever what will come tomorrow. So that's why the responsibility is in the first place on us as the members of the authorities in the countries to be vivid, to be ready to react on everything which is changing on an everyday basis. But we have to understand that we, as the government authorities, are not the only ones which are taking care about this area in our societies. the civil society is there as well. And if we really want to form a unified, let's say, front, if you like, when it comes to the tackling of the cybercrime, and on the same time respect of the civil society and human liberties, we have to actively cooperate and coordinate with the private sector, with the civil society groups, and jointly reach the let's say solution which will be on the first place good for our countries and our respective societies. Of course, we have to look towards the general solution, which is on the international level. And so far, me being as a practitioner in this area for last 15 years, I really cannot find a better solution for rooftop legislation or legislative framework on the international level than its Budapest Convention as it is in this moment. Thank you very much.
Thank you, Branko. We don't need to go through a country-by-country discussion now because of time constraints. But there's one point I would like that I find interesting in Serbia also. You're focusing much more on complex cases of cybercrime involving money, fraud, and so on, and therefore much more cooperation with the financial sector also. And again, the issue of how to cooperate, how to exchange data with the financial sector, the issue of data protection also comes into there. So these are things we have to also take up later today. Any other burning remarks you want to share about cybercrime situation in your country? Not so much about legal framework, because that we discussed this afternoon, but does this mean no cybercrime anywhere else apart from Serbia? Turkey, but please let's keep it short now, because Serbia. But we need the microphone to Turkey. Sorry, the microphone is coming.
Tayyar Ögmen, Minister of Justice of Turkey, Mutual Assistance Department in Criminal Matters. Thank you for your presentations. Every day it's becoming more complex, and when we look at as he said, and when we look at the Article 19 of the Cybercrime Convention, we see their national in the border of national. But when we are looking now, there's an iCloud. I think iCloud means it will be more complex, and we have many problems in the execution of judicial requests, especially United States, as like other countries. In terms of iCloud, for example, Google or other things, and our requests are increasing. Maybe 4 years later, it will be huge in terms of all of the countries, and I think this is the very interesting point, and I saw this is very big problem in the application of Cybercrime Convention. Thank you.
It's indeed a very interesting one, because Article 19 is about search and seizure, as you all know, and Article 19 allows you to, well, it requires governments to allow their law enforcement to extend the search to connected computer system in its territory. So there is a territorial boundary there, and many say we don't know where the data is. We don't even know to whom to send an MLA request. Maybe the data is in different countries. Maybe the data is in different countries at the same time because there may be backups. The data may be mirrored and so on. So where is the data? Sometimes data is fragmented over servers in different countries. So major problems coming up. These are also the issues we try to look at in this work on transporter access that the Cybercrime Convention Committee is looking into, and hopefully in December we will advance in that, and hopefully soon also Turkey will be a party so that they can actually make use of it. Okay, please, can you take the...
Thank you. Can you hear me? Okay. First of all, I wanted to add something regarding the convention. Oh, I'm sorry, I didn't present myself. I'm Denise Asko. I'm a prosecutor from Albania, from District Prosecution Office of Shkodra. I want to say something regarding the convention and its ratification by our country. You know, as I believe all of us in here already have the law enforcement safeguards and human rights. So I believe that the convention and the implementation into the domestic legislation already needs to be regarded as a whole with the entire legislation, criminal and procedural legislation. That's my first point. And the second one is that, of course, that this convention is relevant because in every criminal offense, now actually, there are always digital evidence. So it's not that we have only digital evidence regarding the criminal offenses related to computers, but we have digital evidence in every other criminal offense by the great use of technology in our modern times. So I think it's really important to analyze this aspect regarding this point of view, because the digital evidence will be in use in every proceeding. Thank you.
Okay, very interesting points. We had worked with Diana on the legislation some years ago of Albania, and we see in Albania a good level of implementation also of the procedural law provisions. But the Cybercrime Convention Committee, apart from working on the transporter issue question, is also analyzing implementation of the Budapest Convention by the parties, and right now we're analyzing Article 16, 17 on expedited preservation at a domestic level, and Article 29 and 30 on expedited preservation at the international level. And we note that in many countries there is not really an adequate implementation of these provisions, in the sense that instead of going through the preservation step, which allows you for the time to go to a judge and get the proper warrants and everything, half or more of the parties to the convention go directly for search, seizure or production orders. So there may be an issue there also regarding respect for conditions and safeguards and so on, because the possibility of preservation is exactly that, to give you time to go through the proper process before then asking for the disclosure of data or before having a search and seizure. So there are some issues there. Albania is on a very good track. With quite a number of other parties, we may see, again, the plenary of the TCY in 1 month will discuss the results of the assessments, the second round of discussions already, and hopefully also adopt the report on assessing, on the assessment of Article 16, 17, 29 and 30. Okay, with that, should we have a coffee break? And we come back in about 15 minutes. Apparently there is coffee just next door. Oh, on the main corridor there is coffee. Please come back in 15 minutes so that we can then continue. Thank you.
На факт nu kush tu tek provat. Ktu është mirë të mbledhje prova, nuk është thjesht mbledhje. Që në momentin e kap që ti e kap, si do të kapësh? Problemi i këtij konventi i Shqipërisë, për shembull, është ti e kap, po ti e kap për ta bërë si provë, në fakt, ka një periudhë ndërmjet kapjes, bajtjes, një pra, ekspedajt edhe si zërja